All rise, veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du tribunal pénal international pour l'ex-Yougoslavie est ouverte. Please be seated.
Good afternoon, ladies and gentlemen. The appeals chamber of this international tribunal is meeting today pursuant to a scheduling order issued on the 8th of October designating this date of October 23rd, 2001 as the day for delivery of judgment in the appeals of Prosecutor versus Zoran Kupreskic et al. The registrar will make copies of the written judgment available to the parties toward the end of this hearing. I will not read out the text of the judgment except for the disposition, but following the practice of this tribunal, I shall limit myself to a summary. But I emphasize that the only authoritative account of the appeal chamber's conclusions and its reasons are to be found in the written judgment. First, I would like to ask the counsel for the parties to identify themselves, beginning with the prosecution.
Thank you, Your Honor. I'm Upawan Siapa, appearing for the prosecution, with Mr. Anthony Carmona, Mr. Fabricio Guariglia, Ms. Sonia Bulat Suominen, and Ms. Norul Rashid. Mr. Wolfgang Sakulin is our case manager. Thank you.
Thank you. I would like the defense counsel to begin. You may begin, Mr. Radovic.
Good afternoon, Your Honors. My name is Ranko Radovic, defense counsel for Zoran Kupreškić, and with me is Mr. Tomislav Pasovic, the co-counsel.
Thank you.
Good afternoon, Your Honors. My name is attorney Jadranka Slokovic-Glumac for Mirjan Kupreškić and co-counsel lawyer Desanka Vranjicen.
Good afternoon, Your Honours. I appear on behalf of Vlatko Kupreskic, Anthony Abel, together with my co-counsel, Mr. John Livingston.
Good afternoon, Your Honors. My name is attorney Petar Pavkovic. I'm defense counsel for Vladimir Santic.
William Clegg and Valerie Charbit for the appellant Josipovic.
Thank you. I would next like to be assured that all of the defendants are able to hear these proceedings by their microphones in the language that they can understand. If you just nod to make sure that. Thank you. Now, before beginning to read out the summary, I would like to express my thanks to both the prosecution and defense counsels for their cooperation during this appeal. And I'd also like to take this opportunity to thank Mr. Yapa because he is appearing, as I understand, before this chamber for the last time as the senior appeals counsel and will move on within the prosecutor's office to a different position of senior trial attorney. Thank you all. I will now begin the summary of the judgment. Around dawn on the morning of April 16th, 1993, Bosnian Croat forces engaged in a surprise attack on the Bosnian Muslim inhabitants of Ahmici, a small village located in central Bosnia. The trial chamber found this was not a lawful combat operation, but rather a deliberate attack on civilian Muslims by the Croatian Defense Council, otherwise known as HVO, as part of a campaign to cleanse the village of Ahmici of its Bosnian Muslim inhabitants, which in turn was part of a broader strategy of expelling Bosnian Muslims from the Lazva River Valley region. Specifically, the trial chamber found that over 100 civilians, including women and children, were killed in Ahmici that morning, and that 169 Muslim homes were destroyed, along with the 2 mosques in the village. The presiding judge of the trial chamber said this: "What happened on April 16th in Ahmici has gone down in history as comprising one of the most vicious illustrations of man's inhumanity to man. Today, the name of that small village must be added to the long list of previously unknown hamlets and towns that recall abhorrent misdeeds and make all of us shudder with horror and shame. Dachau, Oradour, Sirglan, Katinj, Marzabato, Soweto, Mailai, Sabra, and Shatia, and so many others." This case is one of several emanating from the Ahmici massacre, some of which have involved high-level civic and military leaders from the region. The trial chamber here had before it 6 Bosnian Croat defendants, all of whom were inhabitants of Ahmici or the surrounding area. Only one held a formal military command position. The rest worked in the local area. They were store owners, factory workers, and the like, who up until the war lived out their lives in relative harmony with their Muslim neighbors. 2 of the defendants, Zoran and Mirjan Kupreškić, are brothers, and a third, Vlatko Kupreskic, is their cousin. One of the defendants, Dragan Papić, was acquitted of all charges following the trial. The remaining 5 defendants were all convicted of persecution as a crime against humanity. Zoran, Mirjan, and Vlatko Kupreskic were acquitted of the remaining counts against them, which had alleged murder, cruel treatment, or inhumane acts as violations of crimes against humanity or violations of the laws or customs of war. They were sentenced to 10, 8, and 6 years of imprisonment, respectively. In addition to persecution, Drago, Josipovic, and Vladimir Santic were each found guilty on 1 count of murder and 1 count of inhumane acts, both as crimes against humanity, but acquitted on 1 count of murder and 1 count of cruel treatment as violation of the customs of war. They were sentenced to a total of 15 and 25 years of imprisonment, respectively. Today, the appeals chamber decides the appeals brought by the prosecution and each of the defendants against the judgment rendered by the trial chamber 2 years ago. The prosecution's appeal is confined to the legal issue of whether the trial chamber erred in declining to convict Josipovic and Santic for violations of the laws or customs of war under Article 3, as well as for crimes against humanity under Article 5 of the statute, based on the same underlying conduct. Deciding the challenges levied against convictions and sentences by the 5 Bosnian Croat villagers who were almost 2 years ago found guilty by the trial chamber has proven to be a fact-intensive exercise. This appeal was also characterized by an extremely complex pre-appeal process in which 26 separate motions to introduce new evidence on appeal were disposed of under Rule 115 of the Tribunal's Rules of Procedure and Evidence. The conviction of one defendant, Vlatko Kupreskic, hinges upon a finely woven web of circumstantial evidence that was accepted as proof beyond reasonable doubt by the trial chamber. In the case of the remaining 4 defendants, each of the guilt of each one has been determined principally on the basis of a single witness who placed them at a particular location when a murder or expulsion occurred. Most of these accused disputed the identification evidence given by the witnesses against them and claimed that the critical witness testimony was too slender a reed upon which to establish their participation in the Ahmici attack. Thus, the appeals chamber has been confronted with an issue that domestic jurisdictions have struggled with over centuries: the circumstances in which it is reasonable for a finder of fact to rely upon identification evidence given by a single witness. In addition to their main contention that the evidence was too weak to support their convictions, several accused raised procedural challenges which they claimed cast serious doubt upon the fairness of their trial. The function of this tribunal is to decide the guilt or innocence of individual accused according to standards of procedure and evidence that commend themselves to all civilized nations. Its statute requires that the accused be, quote, informed promptly and in detail of the nature and cause of the charges against him. And the tribunal has adopted a beyond reasonable doubt standard for conviction. Above all, it has striven to follow the principle laid down by the first chief prosecutor at Nuremberg that we must, quote, establish incredible events by credible evidence. It is with these cautions in mind that we have examined the voluminous trial record on which the convictions of the 5 accused before us were based and have come to the following conclusions. The judgment commences with a section in which we consider general issues common to all or several of the appeals brought by the defendants. The appeals chamber underscores that its function is not to carry out a trial de novo, but rather is limited to considering specific errors of law or fact occasioning a miscarriage of justice. The appeal procedure is not a forum for parties to air complaints they have about the trial or the judgment, regardless of how immaterial these matters might be to the findings reached by the trial chamber. In the judgment, we discuss at length the standards for appellate court review of factual findings by a trial chamber. We believe the time has arrived for a thorough discussion of this aspect of appellate review. It has become clear that more and more appeals before this tribunal are focusing on the factual basis underpinning the judgments rendered by the trial chambers, as increasingly the overriding legal issues become more settled with an escalating number of trials and appeals. As to the circumstances in which an appeals chamber will intervene to overturn factual findings made by a trial chamber, we reiterate the trial chamber must be given a margin of deference and that the appeals chamber will intervene only if the evidence relied on by the trial chamber.
Kindly slow down for the interpreters.
Thank you. Could not have been accepted by any reasonable tribunal, or where the evaluation of the evidence is wholly erroneous. Nonetheless, we emphasize that a trial chamber is expected to be especially alert to the vagaries inherent in identification evidence, particularly where the purported identification has been made under difficult conditions. A common denominator in the approaches adopted by domestic jurisdictions around the world is the need to exercise extreme caution before proceeding to convict a defendant on the basis of a single identification witness. Where a finding of guilt is made on the basis of identification evidence given by a witness under difficult circumstances, the trial chamber must rigorously implement its duty to provide a reasoned opinion. A significant issue in this appeal has been the standards governing reconsideration of the trial chamber's findings in light of additional evidence admitted on appeal. During the past few years, the changing political climate in some states of the former Yugoslavia, resulting in the opening of war archives and the release of documents formerly unavailable to the parties at trial, has prompted a deluge of applications for the admission of additional evidence under Rule 115. The appeals chamber therefore takes this opportunity to clarify some of the standards governing the application of Rule 115. In particular, the standard to be applied by the appeals chamber in finally determining whether, in light of additional evidence admitted, a miscarriage of justice has occurred was a subject of strenuous debate by the parties. After careful consideration, the appeals chamber has decided against importing tests from domestic jurisdictions such as a so-called would or could test. Rather, the relevant standard is whether the appellant has established that no reasonable tribunal of fact could reach a conclusion of guilt based on the evidence before the trial chamber together with the additional evidence admitted during the appeal. We turn now to the specific appeals against conviction and sentence of the 5 individual defendants. First, Vladimir Santic. At trial, Vladimir Santic vigorously contested his guilt, relying upon a defensive alibi. He was, he said, not in Ahmici during the 16th April attack. Since his conviction, Santic has admitted that he was the commander of the 1st Company of the 4th Battalion of the HVO military police, and that he was a member of one of the groups that descended upon Ahmici in the early morning hours of 16 April. However, he maintains his objections to certain findings made by the trial chamber regarding the extent of his participation in the Ahmici events. The appeals chamber considers that there was ample credible evidence before the trial chamber that Santic was both commander of the 1st Company of the 4th Battalion of the HVO military police and the anti-terrorist unit known as the Jokers that was formed within the 4th Battalion. It was therefore reasonable for the trial chamber to infer, given the participation of these units in the Ahmici attack, that Santic carried out a command role. It was also open to the trial chamber to conclude, as it did for the purposes of sentencing, that as part of his command role, Santic passed on orders relating to the attack from his superiors to subordinates. Therefore, the appellate chamber rejects Santic's claim that the evidence of witness A.T., admitted as additional evidence on appeal, cast doubt upon the trial chamber's findings regarding his command role. For the purposes of Santic's appeal, witness A.T. is not a credible witness whose testimony impugns the basis of the trial chamber's verdict. The appeals chamber emphasizes further that the interposition by Santic of a new defense after trial through the testimony of witness A.T. must be viewed with extreme skepticism. However, the appeals chamber does accept that the trial chamber was mistaken in inferring for the purposes of sentencing that Santic was involved in the overall strategic planning of the attack. Simply put, the prosecution adduced no evidence at trial that Santic was amongst the architects of the Ahmici assault strategy, and this fact should not have entered into his sentencing decision. A related ground of appeal raised by Santic is that the amended indictment did not allege that he held a command position or played a command role during the attack. The appeals chamber emphasizes that it would have been preferable to allege in the amended indictment that Santic held a command position rather than simply describing him as an HVO soldier. However, the charges brought against him were based upon his individual participation in the attack and not on a theory of command responsibility. While it is true that the trial chamber nonetheless relied upon his command role as an aggravating factor for sentencing, there is no legal requirement that the prosecution plead aggravating factors in an indictment. Furthermore, the appeals chamber underscores that even after knowing the prosecution had adduced evidence about his command role during the trial, Santic made no effort to dispute it, but instead continued to defend himself by relying upon a false alibi. The appeals chamber also rejects Santic's claim that the trial chamber erred in its assessment that he played an active role in the attack on the Puskal home on the morning of 16th April. For reasons discussed in the judgment, witness A.T.'s claim that Santic did not participate in the attack but held back and leaned against the wall is not sufficiently reliable to cast doubt on the trial chamber's determination in this regard. Turning to sentencing matters, Santic has argued that since his conviction, he has accepted guilt and expressed sincere remorse for his participation in the attack, and that he has cooperated substantially with the prosecution by assisting them with their investigations. The prosecution has verified Santic's cooperation. The appeals chamber accepts that Santic has to a limited degree accepted responsibility for his role in Ahmici. Furthermore, although there is nothing in the statute or rules of this tribunal expressly addressing the issue, the appeals chamber finds that in appropriate cases, cooperation by an accused between conviction and appeal may justify a reduction in the sentence, depending on the circumstances of each case and the degree of cooperation rendered. In the present case, we find that a reduction in sentence is justified. In sum, we find that the trial chamber erred only in inferring that Santic assisted with the strategic planning of the attack and considering this as an aggravating factor in his sentencing. In combination with his acceptance of partial guilt and his substantial post-conviction cooperation with the prosecution, the appeals chamber considers him eligible for a reduction in sentence. The appeals chamber has found no merit in any other ground of appeal regarding conviction and sentence. Drago Josipovic. Drago Josipovic advanced 4 grounds in support of his appeal. First, he complained that the trial chamber erred by returning a conviction for persecution based on the evidence of witness D.D., who testified that Josipovic was a member of the group that attacked the house of Nazif Ahmić on 16 April. This attack was not pleaded in the amended indictment. Zoran and Mirjan Kupreškić make a similar argument, to which we will turn later, regarding the vagueness of the persecution count in the amended indictment. It is therefore appropriate at this juncture to clarify some of the relevant general principles governing pleading practices before the tribunal. Each and every accused person brought before this tribunal has the right to be informed of the nature and cause of the charges against him and to have adequate time and facilities for preparation of defense. This guarantee, enshrined in Article 21 of the statute, is at the very heart of an accused person's right to a fair trial. In each indictment, the prosecution must set out the material facts underpinning the crimes alleged in enough detail to clearly inform the accused of the charges against him and allow him to prepare his defense. In contrast, there is no requirement to include in the indictment reference to the evidence by which such material facts are to be proved. Precisely what constitutes a material fact so as to require its inclusion in the indictment cannot be determined in the abstract. Where the prosecution alleged that an accused personally committed a discrete number of criminal acts, the material facts will include matters such as the identity of the victim, time and place of the events, and the means by which the acts were committed. There may, however, be other cases in which the sheer scale of the alleged crimes makes it impracticable for the prosecution to include this kind of detail. An example would be where the prosecution alleges an accused participated as a member of an execution squad in killing hundreds of men, or where in exercising command authority, an accused ordered an attack on a town resulting in hundreds of civilian deaths. The nature of such a case would not demand each and every victim be identified, although the prosecution should attempt to do so to the extent it is able. The present case, however, does not fall into that category. In relation to Josipovic, the allegations against him in the amended indictment were broad-ranging. He was accused of persecution based on systematic killing of Bosnian Muslims and the comprehensive destruction of their property, as well as the organized detention and expulsion of Muslims from the area of Ahmici Santic. However, at trial, the prosecution sought only to prove that he participated in attacks on 3 specific Bosnian Muslim houses in Ahmici. The prosecution could and should have included specific details in the indictment about the handful of attacks on which it sought to implicate, Josipovic. Admittedly, persecution as a crime against humanity under Article 5 is a broad offense, often comprising a series of acts. However, the so-called umbrella nature of the crime does not release the prosecution from its obligation to specifically plead in the indictment the material facts on which the persecution charge is based, with the same detail required for other crimes. The crime of persecution cannot be regarded as a catch-all for any criminal conduct on the part of the accused that emerges during the trial and is not pleaded in the indictment. The prosecution must particularize the material facts of the alleged criminal conduct of the accused that, in its view, define the defendant's role in the persecution. If it fails to do so, the indictment suffers from a material defect, since such an omission precludes, or at least impacts negatively on the ability of the accused to prepare his defense. The appeals chamber finds that without doubt Josipovic's alleged involvement in the attacks on the homes of Musafir Puskul and Nazif Ahmić were material facts underlying the charge of persecution. Neither of these attacks were specifically pleaded as part of the persecution count. They should have been. The appeals chamber does not, however, exclude the possibility that in some instances a defective indictment can be cured if the prosecution provides the accused with timely, clear, and consistent information setting out the factual basis of the charges against him. In this case, the appeals chamber accepts that Josipovic in this case, the appeals chamber accepts that Josipovic did have sufficient notice of his alleged involvement in the attack on the house of Musafir Puskul. Although that attack was not specifically referred to in the persecution count, it was pleaded elsewhere in the amended indictment as the basis for a charge of murder. In that situation, the appeals chamber finds the failure to specifically plead the Puskul attack as part of the persecution count did not materially prejudice Josipovic in the preparation of his defense. Josipovic's participation in the attack on the house of Musafir Puskul can, therefore, serve as a legitimate foundation for the persecution conviction. By contrast, the appeals chamber does not accept that Josipovic received sufficient notice of his alleged participation in the attack on the house of Nazif Ahmić, which was omitted from the amended indictment altogether. For that reason, the appeals chamber accepts Josipovic's argument that the trial chamber was not at liberty to rely upon his participation in that attack as part of the persecution conviction. The second ground of appeal advanced by Josipovic is that the trial chamber erred in accepting the evidence of witness E.E. as a reliable basis upon which to conclude that he participated in the attack on the house of Musafir Puskul. In particular, the trial chamber accepted witness E.E.'s evidence, notwithstanding that she was found to be clearly mistaken in her identification of two other men whom she knew well among the attackers. Josipovic has not argued that the trial chamber failed to direct itself to any material aspect of the trial record that undermined the credibility of witness E.E. Rather, it is obvious from the trial judgment that the chamber was fully aware that witness E.E. was mistaken in her purported identification of at least two of the 6 attackers at the Puskul house, but that it, the trial chamber, nonetheless chose to accept her evidence. Rather, Josipovic asks the appeals chamber to adopt a different conclusion on witness E.E.'s credibility from that of the trial chamber. A trial chamber is at liberty to reject part of a witness's testimony while accepting the remainder. In this case, the trial chamber's decision to rely on witness E.E.'s identification of Josipovic as a participant in the Puskul attack is supported by various other aspects of the trial record. Most significantly, the trial chamber had before it evidence that Josipovic had participated in an additional attack of a similar nature occurring in the same neighborhood during the same time period. The appeals chamber has already determined the fact that Josipovic participated in the attack on the house of Nazif Ahmić cannot serve as a legitimate basis for his persecution conviction because not pleaded in the indictment. However, witness D.D.'s evidence of his participation in that attack can be considered as evidence corroborating his participation in the attack on the house of Musafir Puskul. Josipovic has pursued only one challenge to the credibility of witness D.D., and that is based upon a statement made by witness C.A. admitted as additional evidence. The appeals chamber doesn't accept that this additional evidence undermines witness D.D.'s credibility to the extent it renders her identification of Josipovic as one of the attackers unsafe. In sum, we have heard no argument on appeal that would expose as unreasonable the trial chamber's reliance upon witness D.D. for corroboration purposes. Another factor supporting witness E.E.'s credibility is Santic's own subsequent admission he was present during the Puskul attack, demonstrating that E.E. was correct in her earlier identification of him as one of the group of attackers. The appeals chamber finds no justification for interfering with the trial chamber's assessment of witness E.E.'s credibility as a ground for overturning its finding that Josipovic participated in the Puskal attack. The fourth ground of appeal raised by Josipovic is that the additional evidence of witness A.T. admitted under Rule 15115 calls into question the safety of his conviction. Witness A.T. previously testified before the court at trial chamber that he was present during the attack on the house of Mustafa Puskal, and that witness E.E. was mistaken about a third person she identified amongst the attackers. Witness A.T. also claimed categorically that Josipovic was not among that group. The appeals chamber rejects Josipovic's argument that this new evidence fatally undermines the trial chamber's conclusion that he was involved in the attack. In admitting witness A.T.'s evidence, the appeal chamber emphasizes that it was credible insofar as it concerned the preparation and planning of the Ahmici attack. However, the appeals chamber also takes note of the court at trial chamber's determination that witness A.T. did not tell the full truth about the extent of his own involvement in the attack. The appeals chamber concludes that insofar as A.T.'s evidence relates to other participants in the attack, it is similarly unreliable. He has failed to establish no reasonable tribunal of fact could have reached a conclusion of guilt based upon the evidence before the trial chamber, together with the additional evidence admitted during appeal. Thus, in the case of Josipovic, we find that the trial chamber erred in only two respects: in returning a conviction for persecution based in part on his role in the attack on the house of Nazif Ahmic, not pleaded in the amended indictment, and in making a factual finding that he held a command position vis-a-vis other soldiers involved in the attack. For these reasons, the appeals chamber considers that the sentence imposed upon Josipovic should be reduced. The appeals chamber has found no merit in any of the other grounds of appeal. Zoran and Mirjan Kupreškić. Throughout the trial and in the trial judgment, the cases of the brothers Zoran and Mirjan Kupreškić were closely linked, as based upon similar allegations of participation in the Ahmici events. Their appeals raise many joint issues, and we will address them together. Zoran and Mirjan Kupreškić have argued that the trial chamber erred in convicting them of persecution based on material facts not contained in the amended indictment. In particular, the trial chamber accepted the evidence of witness H that the brothers were present in the house of Sukret Ahmici shortly after he and Meho Hrstanovic were killed, and shortly before the surviving occupants of the house were expelled and the house set on fire. The amended indictment was utterly silent as to the alleged participation of Zoran and Mirjan Kupreškić in these events on 16th April. The principles of pleading detailed earlier apply equally here. The attack on the house of Sukret Ahmic was a material fact in the prosecution case against Zoran and Mirjan Kupreškić. At trial, it was one of only two incidents as to which the prosecution alleged their participation on that fateful day. The trial chamber itself rejected their participation in the other attack. Thus, their involvement in the attack on the house of Sukret Ahmic became the nucleus of the persecution conviction. The omission of any reference to the Ahmic attack in the amended indictment constituted a material fact. The appeals chamber notes the prosecution expressly chose not to further amend the indictment to include that attack in the interests of expediency. The goal of expedience can, however, never be allowed to override the fundamental rights of the accused to a fair trial. The appeals chamber concludes then that the trial of these two defendants was rendered unfair as the result of defects in the amended indictment. In particular, the appeals chamber is not persuaded by prosecution arguments that any defect was remedied by providing Zoran and Mirjan with adequate notice of the allegations prior to trial. The pretrial brief, so heavily relied upon by the prosecution during the course of argument on appeal, is extremely general and makes no reference to particular attacks or murders implicating the Kupreškić brothers. Even during its opening address at trial, the prosecution made no reference to the attack on the house of Sukret Ahmet. Indeed, on the second to last day, the presiding judge was still struggling to understand the precise relevance of witness H's evidence to their case. On the other hand, defense counsel consistently objected to the form of the amended indictment throughout the trial proceedings. In this case, the vagueness of the persecution count in the amended indictment goes to the heart of the substantial safeguards that an indictment is intended to furnish to an accused, namely to inform him of the case he must meet. The appeals chamber, having upheld the objections of Zoran and Mirjan Kupreškić based on the vagueness of the amended indictment, then confronted the question whether the appropriate remedy would be to remand the matter for retrial. The appeals chamber might understandably have been reluctant to allow a defect in the form of the indictment to determine finally the outcome of a case in which there was strong evidence pointing toward the guilt of the accused. However, Zoran and Mirjan Kupreškić have raised a number of objections to the factual findings of the trial chamber, which fatally undermine the evidentiary basis for their convictions. We turn now to these objections. Foremost among their concerns is that witness H, who was 13 years old at the time of the attack and a few years older at the time she gave evidence before the trial chamber, was not a sufficiently reliable witness from which to conclude that they had participated in the attack on the house of Sukret Ahmet. The trial chamber's decision to accept the evidence of witness H was very heavily influenced by her confident demeanor in court and her personal certainty that she was correct in her identification of the Kupreskic brothers that morning. There was no other evidence deemed credible by the trial chamber to directly corroborate witness H's observations. Witness H is a young woman who, in the wake of the Ahmici massacre, has assumed a significant degree of responsibility for her family, and her undeniable courage was reflected in her testimony. That such a witness should make an enormous positive impression upon the trial chamber is not surprising. However, after a careful review, the appeals chamber must conclude that the trial chamber's assessment of witness H's evidence was critically flawed. This was a witness who purported to identify the defendants under extremely difficult circumstances. The attackers descended upon her house in the early morning hours while she and her family were sleeping. Her father was killed as she and other occupants hid in the basement. The attackers had masked their faces with paint in order to camouflage themselves. In such circumstances, it was clearly incumbent upon the trial chamber to proceed with extreme caution prior to accepting witness H's identification evidence as the basis upon which to conclude that the defendants were involved in the attack on the house. Although witness H was a confident and impressive in-court witness, a trial chamber must take into account the fact that when it comes to identification evidence, the degree of certainty expressed by a witness is not necessarily an indicator of its reliability. Rather, a trial chamber must thoroughly and carefully consider the evidentiary record as a whole prior to reaching a conclusion about the credibility of the witness. Such caution is not sufficiently reflected in the treatment accorded to witness H's evidence. Most significantly, the trial chamber failed to direct itself to another material piece of evidence, namely the statements made by witness S.A., a close relative of witness H, also present during the attack. Throughout the trial, Zoran and Mirjan Kupreškić were insistent that witness A be called to testify. She was, they said, the only other eyewitness who could shed light upon the events in the Ahmici house, and she had made prior statements that cast some doubt upon important aspects of witness H's in-court testimony. At first, it appeared that the prosecution would itself call witness S.A. as part of its own case. Later, when the prosecution abandoned that, the trial chamber, acknowledging the reality that the Kupreskic brothers would have little chance of securing her attendance as a defense witness, named S.A. as a court witness. However, the trial chamber subsequently retracted that decision upon being informed by a staff member of the Victims and Witnesses section that S.A. could not attend for health reasons. In so doing, the trial chamber fell into error. although the rules of this tribunal provide a trial chamber with wide discretion in deciding who it will name as a court witness, having decided to call S.A., the trial chamber should not have retracted the decision to the detriment of the defense in the absence of certification from a qualified health professional demonstrating that she was indeed medically unfit to attend. In an attempt to compensate for S.A.'s non-appearance before the tribunal, the trial chamber agreed to admit 6 of her prior written statements. The trial judgment reveals, however, that it subsequently reviewed these 6 statements only to see if they provided support for witness H. The trial chamber failed to take the critical step of considering whether the statements of S.A. cast doubt upon the identification evidence of H. The appeals chamber finds that they do. Among other things, these statements raise a distinct possibility that witness H's identification of Zoran and particularly Mirjan Kupreškić as participants in the attack on her house gradually developed in the months following the April 1993 atrocity. The trial record reveals that immediately following the attack, there was extensive speculation among the Bosnian Muslim members of Ahmici, in particular witness H's family, about the involvement of their Croat neighbors in the attack. The trial chamber should have evaluated the possibility that witness H, a child at the time, was influenced in her belated identification by this speculation within the family circle. The trial chamber also failed to direct itself to material discrepancies between witness H's in-court testimony and the prior statement that she herself made, which, among other things, cast some doubt upon her claim of an adequate opportunity to identify the Kupreskic brothers during the early morning attack. Additionally, witness S.A.'s statements provide no support for witness H's claim that she had such an opportunity. The trial chamber omitted to make any specific factual findings about these and other crucial matters affecting H's credibility, such as her outright denial that she had made a prior, somewhat inconsistent statement to an investigating judge in Zenica, and her mistaken claim that she recognized Zoran Kupreskic as an employee of a shop she frequented. The trial chamber also did not account for the distinct likelihood stemming from witness H's description of the brothers' physical appearance that day that she may have mistaken them for 2 members of the Joker's unit of which they were not members. We did not find that sufficient attention was paid to these crucial identification questions by the trial chamber to permit us to conclude that its obligation to provide a reasoned opinion had been fulfilled. The appeals chamber has also had the benefit of the additional evidence of A.T., which has illuminated certain matters regarding the organization of the Ahmici attack and served to highlight some of the difficulties associated with the trial chamber's treatment of witness H's evidence. The task before this trial chamber in this case was difficult. It was confronting problems triggered by a trial record that contained important omissions, such as the live testimony of S.A., a key eyewitness. A trial chamber must proceed with great caution before convicting an accused person based upon a trial record that contains patent omissions. The difficulty of obtaining all the relevant evidence, unfortunately inherent in many cases that come before the tribunal, cannot and does not reduce the prosecution's burden of proving the guilt of an accused beyond reasonable doubt. To recapitulate, we recall that the Kupreskic brothers were prejudiced as a result of, first, the prosecution's failure to allege the attack on witnesses H's house in the indictment, and second, the late disclosure of her earlier statements. The defense had only a few weeks to prepare for the cross-examination of this witness, who turned out to be a linchpin in the case against them. If witness H's testimony is discounted, the cases against Zoran and Mirjan Kupreškić cannot stand. The trial chamber drew some support for their participation in the Ahmici attack from the evidence of witness J.J., who said that on that day, under threat by the Joker, Zoran Kupreškić had said that he shot into the air in the pretense of shooting at civilians. However, without witness H's evidence, witness J.J.'s observations are an insufficient basis upon which to attribute criminal responsibility. Finally, the appeals chamber can find no basis for the trial chamber's finding that the 2 brothers were involved in a persecutory campaign stemming back to October '92. The trial chamber provided no description of what illegal conduct it attributed to the defendants during the period from October 92 to 15th April 93, when they were alleged to have been involved in the preparation of the 16th April attack. Hence, this finding must be rejected due to the absence of any evidentiary basis to support it. In totality, the appeals chamber concludes the convictions of Zoran and Mirjan Kupreškić have occasioned a miscarriage of justice and must be reversed. Vlatko Kupreskic. Among all 5 defendants before the appeals chamber, the evidence to support the conviction of Vlatko Kupreskic was the least compelling. The prosecution did not allege he was directly involved in any specific attacks on Bosnian Muslim homes on the morning of 16th April. Rather, his convictions were based on a web of circumstantial evidence grounded on the trial chamber's findings he was a police operations officer. This led the trial chamber to conclude he had aided and abetting the preparation of the Ahmici attack. On appeal, Vlatko Kupreskic has argued the trial chamber's factual findings about his involvement in the attack had no basis in the evidence to begin with, and second, additional evidence admitted on appeal served to underscore the extreme weakness of the case against him. We accept that on the basis of the trial record, it was reasonable for the trial chamber to conclude that Vlatko Kupreskic was at one time a police operations officer. The trial judgment suggests that this finding, however, was an important factor in its decision to convict him of persecution. From his status as a police officer, the trial chamber inferred that conduct, innocent in its own right, was directed toward assisting, encouraging, or lending moral support to the crime of persecution. However, the totality of the evidence, the trial record, and the additional evidence admitted overwhelmingly suggest that any police duties undertaken by Vlatko Kupreskic ceased in February 1993. There is no satisfactory evidence that his employment with the police continued until the time of the April attack. As to the trial chamber's finding that Vlatko Kupreskic assisted the attacked by providing his house as a base for attacking troops, we accept that this too was reasonable on the basis of the original trial record. The evidence of troop movement in and around the defendant's house came from 4 separate sources. However, the appeals chamber admitted additional evidence on this point. The evidence of witness ADA, who said he was sitting on a hill outside Vlatko Kupreskic's store throughout the afternoon and early evening of 15 April and saw neither Kupreskic nor any troop activity, was not in itself compelling. However, the evidence of witness AT that the plan to attack Ahmici was not announced until the afternoon of the 15th April, troops were not deployed to the bungalow until late into the night between 15th and 16th April, makes it highly unlikely another set of troops would have been dispatched to Vlatko Kupreskic's house much earlier in the day to prepare for the attack. Consequently, the appeals chamber must conclude there is serious doubt as to whether there were troops at Vlatko Kupreskic's house in the early evening of 15th of April preparing for the attack. The remaining evidence against Vlatko Kupreskic provides an insufficient basis upon which to conclude that he aided and abetted persecution. At trial, a witness gave evidence that in October 1992, he saw Vlatko Kupreskic unloading weapons from his car, taking them into his house. There was no evidence of what kind or how many the weapons were, nor that they were ever used during or had any connection with the 16th of April attack, which occurred 6 months later. In the appeal chamber view, it was unreasonable for the trial chamber to infer on the basis of this scant evidence that Vlatko Kupreskic had engaged in acts specifically directed to assist, encourage, or lend moral support to persecution acts against the Muslim neighbors 6 months later. The trial chamber also found Vlatko was in the vicinity shortly after the attack on Sukrit Ahmić's house, and thereby concluded he was ready to lend assistance in whatever way he could to the attacking forces. This finding was based on the evidence of witness H corroborated by witness KL, who who testified to seeing Vlatko Kupreskic after the attack on the Ahmici house in front of the garage. In the appeals chamber view, this evidence, even if believed, is an insufficient basis for the trial chamber to conclude Vlatko was assisting in the attack. He lived in the village. In the context of such a small town as Ahmici, it is risky to draw inferences of guilt simply from the fact that a person was seen in the area of an attack, especially close to his own home. It constitutes only the merest of circumstantial evidence that he was a participant in the attack and is an insufficient basis upon which to found his conviction for persecution. We conclude on the whole that the conviction of Vlatko Kupreskic has occasioned a miscarriage of justice and must be reversed. We turn finally and briefly to the prosecution's appeal. The least contentious of all issues before the appeals chamber was the prosecution's claim that the trial chamber erred in failing to enter convictions for Josipovic and Santic under Article 3 based on the same conduct as their convictions under Article 5. In the intervening period between the rendering of trial judgment and the hearing of the appeal, the issues of cumulative charging and convictions have been clarified considerably in the tribunal jurisprudence. Following the appeal judgments in Celibici and Jelicic, it is now beyond dispute cumulative charging is generally allowed and that cumulative convictions under Article 3 and Article 5 are permitted. For that reason, we uphold the prosecution's appeal and find the trial chamber erred in failing to convict Josipovic and Santic of murder and cruel treatment as violations of the laws and customs of war under Article 3. However, given that the prosecution specifically stated it was only seeking a reversal of the acquittals and not any increase in terms of imprisonment, these additional convictions have not been considered as laying the basis for any change in the sentencing. Now I will read the formal orders made by the appeals chamber in the disposition section of the judgment. Zoran and Mirjan Kupreškić, will you please stand? The appeals chamber unanimously allows your ground of appeal objecting to the trial chamber's decision to return convictions under Count 1 of the amended indictment on the basis of material facts not pleaded therein, namely participation in the attack on the house of Sucret Ahmic. Allows your ground of appeal objecting to the trial chamber's decision to rely upon the identification evidence of witness age to conclude that you participated in the attack on the house of Sucret Ahmic on 16th April, thereby committing an act of persecution under Count 1. In light of additional evidence admitted on appeal, allows your ground of appeal objecting to the trial chamber's finding that you provided local knowledge and the use of your houses as basis for the forces attacking Ahmici. Zoran Kupreskic, we allow your ground of appeal objecting to the trial chamber's finding that you bear criminal responsibility for persecution stemming back to October 1992 under Count 1 of the amended indictment, and we apply this finding also to Mirjan Kupreškić. We dismiss or decline to consider all other grounds of appeal. Accordingly, the appeals chamber reverses your convictions for persecution under Count 1 and finds each of you not guilty on this count. You may both sit down now. You may both sit down. Vlatko Kupreskic, will you please stand? The appeals chamber unanimously, in light of additional evidence admitted on appeal, allows your ground of appeal objecting to the trial chamber's finding that you were an operations officer at the time of the 16th April attack. Allows your ground of appeal objecting to the trial chamber's finding that you assisted with the 16th April attack by unloading weapons from your car in 1992 October. Allows your ground of appeal objecting to the trial chamber's inference that by virtue of your presence outside Hotel Vitez on 15th April, you aided and abetting persecution. In light of additional evidence admitted on appeal, allows your ground of appeal objecting to the trial chamber's finding that there were troops at your house early evening 15 April and that you thereby aided and abetted persecution. Allows your ground of appeal objecting to the trial chamber's inference that on the basis of witness testimony, placing you outside the house of Sucret Ahmic after it was attacked, you were ready to lend assistance to the attacking forces and you thereby aided and abetted persecution. Accordingly, the appeals chamber reverses your conviction for persecution under count 1 of the amended indictment and finds you not guilty on that count. You may sit down now. Drago Josipovic, will you please stand? The appeals chamber unanimously allows your ground of appeal objecting to the trial chamber's decision to return convictions under count 1 on the basis of material facts not pleaded, namely participation in the attack on the house of Nazif Ahmić, but finds no remedy except with respect to your sentence. Allows your ground of appeal objecting to the trial chamber's inference you were in a position of command during the Ahmici attack. Dismisses all other grounds raised by you against your conviction. Accordingly, the appeals chamber affirms the convictions entered by the trial chamber against you on count 1, count 16, and count 18. But as to your appeal against your sentence, the appeals chamber unanimously, having previously found that the trial chamber erred in concluding that you played a commanding role during the attack on the house of Nazif Ahmić, finds that the trial chamber erred in relying upon that factor in aggravation of your sentence. Having previously found the trial chamber erred in considering your participation in the attack on the house of Nazif Ahmić as part of your persecution, finds that the bases for your conviction are now reduced, dismisses all of the grounds raised by you against your sentence. Accordingly, the appeals chamber revises your total sentence from 15 years of imprisonment to 12 years. You may sit down. Mr. Santic, will you please stand? The appeals chamber unanimously allows your ground of appeal objecting to the trial chamber's implicit finding that you assisted in the strategic planning of the attack. Dismisses all other grounds raised by you. Accordingly, the appeals chamber affirms your convictions under counts 1, 16, and 18. As to your sentence, the appeals chamber unanimously, having previously found that the trial chamber erred in finding that you assisted in the strategic planning, allows your ground of appeal objecting to the trial chamber's consideration of this factor in aggravation of your sentence, allows your ground of appeal based on the argument that your sentence should be reduced in light of your acceptance of guilt and your substantial cooperation with the prosecution, dismisses all other grounds of appeal raised by you against your sentence. Accordingly, the appeals chamber revises your total sentence from 25 years of imprisonment to 18 years. You may now sit down. The appeals chamber unanimously allows the prosecution's appeal against the trial chamber's ruling that counts 17 and 19 were improperly charged cumulatively with the counts containing Article 5 charges for murder and for inhumane acts. Allows the prosecution's appeal against the trial chamber's acquittal of Josipovic and Santic under counts 17 and 19. So accordingly, we reverse the trial chamber's acquittal of Josipovic and Santic under 17 and 19, find them guilty under these counts. The appeals chamber finally dismisses Drago Josipovic's ground of appeal by which he complains he was impermissibly charged and convicted cumulatively of murder and other inhumane acts as crimes against humanity because the two charges were in fact based on different facts. Dismisses as abandoned during argument and in the final brief on appeal his original ground of appeal by which he complained he was impermissibly charged with both murder and persecution as a crime against humanity based on the underlying conduct. Pursuant to Rule 101C, an accused is entitled to credit for time spent in custody pending surrender to the tribunal or pending trial or appeal. Accordingly, both Drago Josipovic and Vladimir Santic are entitled to credit for the time they have spent in custody since their surrender on 6 October 1997. In accordance with Rules 103 and 107, the appeals chamber orders Drago Josipovic and Vladimir Santic to remain in the custody of the tribunal pending the finalization of arrangements for their transfers to the states where their respective sentences will be served. In accordance with Rule 99A of the rules, the appeals chamber orders that Zoran, Mirjan, and Vlatko Kupreskic be released immediately from the United Nations detention units. The appeals chamber's reasons for these orders are now published, and with that, we adjourn this proceeding.
All right.
Your Honors, may I say something, please?
I'm sorry.
Relax, right?
You check.